live. You're looking at live pictures here in the Cuyahoga County Court of Common Pleas. This is going to be the sentencing for Preston Anderson. This is a horrendous crime. A woman, 41 years old, was his victim, tortured, locked up in an apartment. She was only able to escape when he left the apartment. She ran down to the security desk, and we should be seeing Preston here shortly. This should be his entrance, as there could be some fireworks today. Let's be very honest. Preston, in one of his arraignments, although now it looks like he's asking for his defense team to come back and talk, he has pleaded guilty to a lengthy list of charges. So we did not go to court on this. Making sure that looks like the judge just gave our photographer some sort of message, as she did not look happy that she was on camera, and he has suddenly turned the camera away. We'll get to that. We'll get to those pictures in a second. Now, let's talk about what Preston Anderson has already pleaded guilty to. There was no trial. Pleaded guilty to gross sexual imposition, abduction, aggravated assault, and strangulation. This is the case that you might remember. The woman was burned in several places. Now we see Preston coming in. He had poured hot oil on her on apparently a couple of different occasions, had apparently used a knife to cut her up. There could be some very graphic testimony here in this sentencing. And again, Preston himself has not been very cooperative. In his arraignment, he flipped off the judge, had some expletive, colorful things to say. And so we're wondering how today is going to play out. Let's take you now live to the sentencing of Preston Anderson.
Mr. Anderson is in court with his attorneys, Chris Julian and Sheila Downs. And on behalf of the state of Ohio is prosecutor Lisa Taroso and Omar Sadiq. We are here for sentencing today. Before me, I have a reintegration plan, a social history report from the Cuyahoga County Public Defender's Office, a certificate of achievement, and a memorandum, sentencing memorandum filed on behalf of the state of Ohio. Is there any reason not to move forward on behalf of Mr. Anderson?
No, Your Honor.
Thank you. Before we get started, were there any issues that the parties wish to address on behalf of Mr. Anderson?
No, Your Honor.
Okay. On behalf of the state of Ohio.
Thank you, Your Honor. Good morning.
Dan DeRosa at Channel 19, and I do just want to warn you, this could be very graphic testimony here given to the judge before sentencing.
Been notified. I've called for her twice outside, and she is not present. Your Honor, as another preliminary matter, I know that in the state sentencing memorandum there were 50 exhibits. I spoke about an injury in that memorandum, a grade 1 vertebral artery blunt cerebral vascular injury, which was noted in the medical records that were provided several months ago, possibly last year, to defense. However, I neglected to reference where they are in the medical records, and so I have documented that as State's Exhibit 51. Your Honor, may I approach?
You may.
Thank you.
Which case is this referring to?
This is the July incident.
Which case number is that?
That is 683563.
Okay.
Thank you, Your Honor. Your Honor, this the court is in receipt of the state sentencing memorandum. Your Honor, so you are aware that this is these are cases, 2 out of the 3 cases, 683563 as well as 691257 involve the same victim, and they are domestic violence cases by their nature. Your Honor, I know that, I'm sorry, 683563 and 683518. I apologize, I misspoke, but those two cases involve the same victim. Those are domestic violence cases, and in terms of the victim and the state, they've followed the way that so many of these domestic violence cases go. So it did not take long for the victim to begin to feel bad that the defendant was incarcerated for what he had done to her. It did not take much for her to recant, for her to attempt to recant. But Your Honor, there has been much made, not with the court, but between the parties, about the victim causing these injuries to herself. And I just wanted to show a couple of very short clips from the body camera. Your Honor, this would be State's Exhibit 52, and this is just a very short clip showing when the victim in this case ran from Arby's to Walgreens, attempted to get help. They took her back into a locked area where their lockers were and tried to get her medical attention. So this clip is from that.
And what case is this?
Your Honor, this is 563.
683563.
Yes.
What's your name?
Hello.
Hi,
I got burned the other day, and I like to really burn up my arm and my vagina. And I had hot oil and water thrown on it.
Hot oil and water.
Yes! It was thrown on my arm and thrown on my vagina and thrown on my face.
Just take a deep breath. I'm sorry.
Your Honor, that is from the 683518 cases, or Lakewood police, some Cleveland officers and EMTs that spoke with the victim in this case. Initially, they were first responders. The next three clips are also from 683518.
So I want to make sure before you get out there and take you down, you don't want any police involvement in this whole mess. You just want that.
I need help. I need you to know.
Hang on one second.
If you can know, they tell you to.
No, that's, I need medical attention. I understand what you're saying, but that.
Play.
Your Honor, the next clip is when police respond to the store and the defendant is present on the other side of the window.
Bus stop, I guess, with her boyfriend, and she came in screaming. She needs to call the police. We took her back. He's in there beating on the door. He won't leave her alone. Not that I've seen. He's just being told all the time.
Come on, man. See, they here. Come on, man. What's going on, man? See those weird ass shit. I don't know what's going on. Far this time I got this and sit down right there. And I don't know what the fuck's going on. They here?
Hey, quiet down. Talk to us. Step over here. Give me your weapons on you.
Okay.
Your Honor, the last clip, the officers had to take Miss Bischoff out to the ambulance past where the defendant was standing near a patrol car speaking with other officers. And so the last of the body camera clips just show an exchange on the ambulance.
Trying to breathe for us, okay? We're trying to get that blood pressure to read.
Dana, just so I can tell the hospital, how long ago did you get these burns?
I don't want to talk about anything, because now he's fucking thinking that I fucking told him for something I ain't telling him for shit. I wouldn't even tell you. I don't even tell him I didn't know. But she don't understand. You didn't know. I didn't know you that you did it.
Right, you didn't. That's exactly right. We are concerned about the burns you had. So in order to get the right care at the hospital, you have to tell us. It was like a week, right?
Oh, well, maybe a week, I don't know.
Maybe a week. Okay, all right. That's just what I needed to know. Maybe a week. Okay, all right. That's just what I needed to know.
Your Honor, I think that those clips make it clear that this was not a case where the victim in this case became angry with the defendant, poured hot oil all over her body, broke her own bones, injured her own neck on either occasion, whether we're talking about 683-518 that occurred in March of 2023, or whether we're talking about 683-565 that occurred a few months later in July. In neither case, the victim did not get mad at the defendant. She did not make this up. She did not do this to herself. The injuries, the court has photographs of the burns, and I've referenced the injuries in the state sentencing memorandum. So the court is aware of the injuries that were suffered by Ms. Bishop in this case. Your Honor, that is a factor under the sentencing, the physical harm, the psychological harm. Remorse or lack of remorse is a factor, and I would point the court toward State's Exhibit 40, which is a 6-page letter that the defendant wrote to the victim from jail. And at the very top, he says, read it every day, hang it somewhere. It's very important you know and remember this. And he proceeds to give her step-by-step instructions on what explanation she should give for each of the injuries that she has. Broken ribs, bruise on her neck, knocked out teeth. Tells her what not to say because there's no evidence to back that up. He says on what is the 4th page, although they're not numbered, if you flip to the 4th page at the bottom, baby, they need you in order to convict me and find me guilty. If you say I did one thing to you, it's over with for me. I'm looking at 18 years if found guilty. The next page, he talks about how rules are meant to be broken and they should be together and contacting each other, even with orders in this case, despite orders in this case. Remember, you did all this to yourself because I said I didn't love you and want to be with you anymore and was accusing you of cheating. So you felt like the best way to get back at me was by doing it all yourself. Whatever you tell them, make it sound great and make sense. Baby, I love you so much. Your Honor, I think that that along with the final clip is a jail call from March of this year.
The brother that don't talk in Texas, the lawyer going to tell her that they may not need the victim. They might just be able to use her statements and what the doctor reported, what the doctor's going to say. But I showed him I showed him in the book already. I showed him in the trial book that the only way that can happen is they had an opportunity to cross-examine her already, which means that she came to court or trial and they had an opportunity to cross-examine her. She never showed up, so that means they never had a chance to cross-examine her. So that means the Sixth Amendment, you have a right to say so to the accuser, the Confrontation Clause, and the 14th Amendment, no person should be denied the liberty, life, and all that due process. So by her not never showing up, if she don't show up, they're going to throw his case out. But if she showed up and then not showing up, they can use her statements. If they had a chance to cross-examine her and didn't. That's why they always say no face, no case, and that's what I was telling them. They tell their sisters, no face, no case. She never showed up at all, to no free trials, no court dates at all. They can't use nothing. If she don't show up 3 times, they're going to throw that shit out. But they're going to find offering a sweet-ass deal so everybody can be happy, so they can get a conviction. If you take a deal, they still get a conviction. So they happy and you happy. You got what you want, you ain't go to prison, and they happy with they got a conviction. That's how they play their game. Sometimes they make you wait all the way into trial, take you all the way down there, try to come with one more deal. The motherfucker be like, no. They be like, all right, you get ready to go there, they just dismiss the case. That's what they did with the one dude. So like all this shit is tricky. I'm sure though that his sister was to come to testify. She's gonna have to be ready to go blow for blow with that motherfucking prosecutor. Because he's not just gonna accept, oh well, he didn't do it, I lied, and I'm just mad, and then it's gonna be like, oh okay, well, this is case, no, hell no, it ain't gonna never be like that. They got some questions. They gonna wanna know who, what, where, why you did it, why that person lied, why she lied, what happened, where you was at, at the time. Then I told them to tell the sister they always ask the victim. They gonna ask her, do you see the person that did that to you in the courtroom? Now I don't know what happened after that. Once you person be like, no, and they in there, they can be like, no, I don't see him. I don't know what happened. I think they still show the dismiss the case. I'm not sure though. Because this rare person that come to court, the defendant in there, and the plaintiff would be like, well, do you see the person that did that to you? And they in there, but the victim would be like, no. And that's what the prosecutor had. They were like, no, so wait a minute, what the fuck you mean to tell me you don't see Mr. Jones right there? You gonna be like, no. Or she'd be like, the person be like, no. They're like, no, Your Honor, that's not right. It's some bullshit objection. The judge is like, sustain and keep going. Like, well, they can accept it. This is bullshit. It's too much. So I told him that he gonna tell the sister just not to come. To avoid all that, not to come. Fuck it.
Yeah, we'll probably be Lisa.
Yeah, basically.
Your Honor, the last thing that I wanted to address is the risk that the defendant posed. There is no doubt that the defendant has mental health issues, that he has had a difficult life, that he has his own issues to overcome. But the state is asking that the court consider the risk that he poses, which is greater with each offense. Your Honor, when you look at his criminal record, he has several prior offenses of violence. In 2006, he had a felony assault. He was found in violation of his community control and sent to prison. In 2007, he was sent to prison for 6 years and violated parole. When he got out, Your Honor, in 2015, he was violent with a woman that he had known, got community control and violated that, and was ultimately sentenced. Your Honor, in 2020, he had 3 cases that involved, 1 was an escape, 2 were involving violence against women, and he received 2 years community control on the mental health docket. Your Honor, despite being given opportunities and services on that docket, the defendant's behavior and violence has only escalated. It escalated from those offenses to the offense in March, and it escalated even further in the offense, the rape offense or the sexual assault in July. Your Honor, I know in my memorandum I talk about the victim's inability, particularly with her own mental health issues, to protect herself. Your Honor, we would ask that the court impose a prison sentence for the protection of the public, specifically for the protection of Ms. Bischoff. I would note finally also that States Exhibits 1 through 12 were pictures from the Cleveland Clinic taken in March of 2023, and those are to go with case 683518 from the same nurse. Those have been provided in discovery to defense, Your Honor. Additionally, in 683563, the state submitted 13 through 38, which are some of the photos from the same nurse at Metro Health who examined Ms. Bischoff in July of 2023. Thank you, Your Honor.
Thank you. On behalf of Mr. Anderson.
Thank you, Your Honor. Your Honor, first off, this case is clearly a very bizarre, very troubling case. As you know, I was appointed to this case in January of 2024, following a prior counsel that had the case. I can tell you that we received discovery, a first packet of discovery in January of 2024, and I was able to review that discovery. I was also able to talk to prior counsel who contacted me and told me that the victim had been contacting him already on the case and indicating that she caused a lot of these injuries to herself and that none of this was Mr. Anderson's fault. Shortly thereafter, the victim in this matter contacted my office. I did not reach out to her. She called me. We scheduled an appointment for her to come in and meet with myself, Ms. Downs, and our investigator. However, the victim didn't wait for that appointment. She showed up at our office. I can tell this court she's a very ill person. She has very serious mental health issues. She has very serious self-harm issues, and I can tell this court a lot of those are documented issues. She did show us and explain to us how many of her injuries of self-harm occurred. There was also a lot of talk about a cell phone that had a lot of videos on it. That was Mr. Anderson's cell phone that had videos of her harming herself. The police officers in numerous body cameras, when they arrested him twice, knew about that. It's on the body camera, the police saying, and Mr. Anderson saying, there's pictures, there's videos of her self-harming herself on my phone. The police never, ever confiscated that phone. They never took it into evidence whatsoever. As a matter of fact, after we filed a motion to dismiss based on the state's failure to preserve that cell phone, we were provided additional body cameras. This was in August of 2024, nearly a year since these offenses occurred, more than a year for some of them. And in those body cameras, we saw the police take Mr. Anderson's phone and put it on the dashboard of the car, never to be seen again. It was not given to him in jail property, it was not entered into evidence, and it was never returned to him. To this day, we have no idea where that phone is or what kind of information there is on that phone. We do know that there are videos on the phone because another independent witness had sent a clip of one of those videos, two clips from that phone to the police back on August 7th of 2023. We received those clips sometime in July of 2024. One that appears to show the victim standing naked, pouring what appears to be hot liquid over herself, and another one that shows the victim sitting on a floor, cutting herself with a knife. So those videos do exist. We don't know what other videos there are because the state did not preserve that phone. Your Honor, we chose, and Mr. Anderson made the decision, rather than to have a hearing and to determine whether or not the case should be dismissed for the failure to the state to preserve that phone, made an agreement with the state of Ohio, worked out a plea deal that we thought would be acceptable for both sides. Your Honor, I can tell you that the victim in this matter has called our office so many times. On April 22nd, she left 55 voice messages on our office phone. So many that our office phones were not able to save them. We had to have staff members literally sit with their cell phone and record each and every message by the victim that we then provided to the state. Those messages nonstop said, Preston didn't do anything. I don't want him to go to prison. I love him. He can't plead guilty to any of this. as recent as probably about a month ago, she has also contacted, again saying she didn't want him to go to prison, and again also indicating to us that she had medical records that she wanted to give to us, documenting a lot of her self-harm. To be perfectly honest, Your Honor, since that point in time, she's become unavailable. Her phone does still take messages, and I can also report that her phone says that her name is Mrs. Preston Anderson, and that if you would like to leave a message for her or her husband, Preston Anderson, you can do so. And that was up until just a week or two ago that her voicemail indicated that. Your Honor, obviously this case has so much discovery, just an overwhelming amount. When we went through all of the first stuff, we thought we had everything. And then slowly, we kept getting more and more, predominantly jail phone calls and jail letters from the prosecutor. I'll be honest, Your Honor, at some point we were like, I can't even listen to these anymore. They were pretty much the same thing. They love each other. They want to be with each other forever. I know there was the issue of the letter that Ms. Taroso indicated. Your Honor, you'll notice that that letter is dated March 8th of 2024. As I indicated previously, the victim in this matter came to our office on January 29th of 2024, 3 months before that letter was even written. And also we have no way of knowing whether the victim actually received that letter. And the stuff in that letter is exactly what she told us. That is not something that Preston told her what to say. He had already heard her saying that. She had already told us that exact stuff before that letter was ever written. Your Honor, just briefly, with regard to the sentencing memorandum and the photos contained therein, there's nothing on those photos that documents what day they were from. We have the medical records. I went through over 2,500 pages of medical records. Some contained photographs. None of those photographs were in any of the medical records that I reviewed over the last several days. I do acknowledge, though, that probably the beginning of August, we were given a flash drive by the state of Ohio, just in a regular envelope, no documentation on it whatsoever other than my name and Ms. Downs' name and Preston's name. Nothing indicating what it was. And to be perfectly honest, Your Honor, we assumed that they were more jail phone calls since that had been all we had been receiving over and over. I did go ahead and look at that today. And those photographs that are in the sentencing memo were on that flash drive. Again, there were no written words whatsoever. There was nothing to indicate what date those were taken. There was nothing to indicate who took the photographs. Nothing at all.
Are you alleging that the state was trying to hide these photos from you?
Your Honor, all I can say is this case has been pending for a year and a half, and we have gotten bits and pieces here and there and buried kind of in a lot of phone calls, jail letters that quite frankly were relatively irrelevant. But also what I'm saying, Your Honor, in reviewing all of those medical records, it's important to know when those photographs were taken and who took them, because Mr. Anderson is charged and pled guilty to offenses that occurred in March of 23 and August of 23, July and August of 2023. Those medical records that were provided to us contain notations from October of 2021, 2 years before this incident, talking about the victim having multiple fractured ribs, talking about her being homeless, talking about her having fallen and had multiple injuries. There are records from January of 2022 that document multiple healing lacerations. And most importantly, Your Honor, there are medical records from February of 2023, not March and not July or August of 2023, that document burns of her groin where she said that she was sleeping and somebody came by and threw hot liquid in her face, neck, waist, and groin. Your Honor, I don't know what is or isn't true. We don't know how she received all of these injuries But as I said, her medical records are, they're just overwhelming. And the number of injuries that one person has had, and not all during the time that Mr. Anderson is charged with, and also various different stories. She's homeless, she's very, very mentally ill, and you know I'm not trying to blame the victim. I met with her, she clearly needs a lot of help. She is very, very ill. It was very hard to direct her when she was in our office, and when she leaves the messages, it's very apparent how ill she is. But Your Honor, that also can't be used against Mr. Anderson in providing these photographs and information on things that we have no idea whether somebody else caused those injuries, how she got those injuries. So for those reasons, that was our concern with all of those photographs that aren't documented. Your Honor, with regard to Mr. Anderson himself, as this court is aware, and we did provide a social history, he has had a horrible upbringing. He was in and out of the foster system. He had so many mental health issues. He never received any of the treatment that he needed. Just looking, and from my experience working in juvenile court, Your Honor, the thing that stands out the most to me is that he did time at Belmont Pines. Belmont Pines is one of the worst juvenile mental health institutions for the most seriously ill people, and to see that Mr. Anderson spent any time at all there is really kind of devastating. It just kind of shows kind of how he was brought up. And the fact that at the age of 18, he was just terminated from the foster care system, as is often the case, and kind of left on his own to fend for himself. He has no family, he has no support system. While he's been in the jail, Your Honor, he has done everything he can. He has actually asked us to assist him in getting some services. I did reach out to Ms. Gray as well as Holly Butterfield in the jail, and they have both been working with Preston and trying to help him out. And I know he's received some certificates while there. We acknowledge that he does have a criminal record. I would also, however, point out that his most recent offenses that the state brought up in 2020, he did receive 2 years of community control on the mental health docket. He also had no violations whatsoever. He successfully completed probation and was successfully terminated from probation on those cases. I know that having a house this time was the first time he's had a house. He recognizes he took responsibility for some of the incidents involved herein. It was a decision we all made together, knowing the difficulty of having a victim with the number of mental health issues that she has, the inconsistency in her stories and the records and everything else. And Preston acknowledges their relationship was not always perfect. There was a very tumultuous relationship. And as much as he loves her, he himself said to us the other day, he cannot ever be with her again, and he recognizes that. And he also knows that it will break her heart, because quite frankly, Your Honor, when she's talked to us, that was her thing, is I'm going to kill myself if I can't talk to Preston anymore. So it is a very difficult position for everybody in this case, Your Honor. I would just ask this court to consider, I know Ms. Gray put together a plan that included placement at the CBCF. I believe that would be a tremendous service for Preston so that he can get the treatment and the help that he needs, and also reintegrate back into society slowly and with some services in place. In the event this court does not think that community control is appropriate, I would just ask for a minimum period of incarceration. Thank you, Your Honor.
Thank you. Mr. Anderson, is there anything that you wish to say?
Your Honor, is it okay if he sits while he reads this?
Of course.
Thank you.
First and foremost, good morning, Your Honor. I don't have much time, so I'm gonna get straight to the point. Your Honor, I want to need help. I was wrong and truly apologize, Your Honor. The decision and choices I made was not the best. I let my emotions influence my actions. In addition to that, Your Honor, I was using and was not on my medication, which played a major part of my mental health. I don't want this letter to seem like I'm making excuses, because I'm not. I take full responsibility for my actions. And as a man, I do admit when I'm wrong, and I was wrong. Once again, I'm sorry. Your Honor, please don't send me to prison. Give me a chance, opportunity to get the help I need and want. The relationship I was in, Your Honor, wasn't the best. Yes, there was some physical, but Your Honor, I'm not guilty of everything I'm being charged with. So again, yes, I played a verbal part into her hurting herself, and this is why I plead guilty to some of the charges. So despite us fighting, I still love her, despite of us fighting and despite me being in here for 13 months. I still love that woman. And I just got some things to point out. The day that I was arrested on that first video count on 117, I was arrested. If she said I burned her, then why was I released? And she's dramatic, Your Honor. I went through this the whole time I've been with her hurting herself, bashing her head into the walls, stabbing herself. And I was told by my counsel just record it, and I recorded. It was 3 other videos in my phone with me sitting there watching her do this to herself. And from my understanding, Ms. Taruso spoke to the security lady that said that can tell you that I showed her the video. Do you still have that paper of that conversation? And I told her the only reason I recorded this video is so I wouldn't get in trouble for it. And obviously I'm still in trouble for it. I did not hurt this girl. This girl did all this to herself.
Okay, thank you. I have considered all of the information that's been presented today. I've reviewed the purposes and principles of sentencing pursuant to Revised Code 29.11, the serious and recidivism factors relevant to these 3 cases and yourself, pursuant to Revised Code 29.12, and the need for deterrence, incapacitation, rehabilitation, and restitution. What we have here, presented by 2 opposing parties, are wildly different versions of the facts involving these 3 cases. The state has made their arguments and the defense has made their arguments. What counts against Mr. Anderson is his history. You have a criminal history involving women and violence against women dating back to 2015. And I will admit that the volume in which the victim is contacting law enforcement, Mr. Anderson's attorneys, is extreme. Stories of victims recanting are not unique. I also can't ignore Mr. Anderson's own words in his letter to the victim. A prison sentence is appropriate in this case. Case 683518, count 1, I'm sentencing you to 3 years in prison. Count 2, the sentence is 180 days. They run concurrent. Case 683563, count 1, the sentence is 18 months. Count 6, the sentence is 3 years. Count 10, the sentence is 18 months. And count 15, the sentence is 3 years. All charges run concurrent. Case 688309, the sentence is 180 days. You've served 413 days of jail credit. This case and the sentence are deemed satisfied. Further, I'm finding that consecutive sentences are warranted in the present cases, and I'm ordering Mr. Anderson to serve the sentences in cases 683518, count 1, and 683563, count 15 consecutively. After reviewing the record and the evidence, I find consecutive sentences are necessary to punish the offender, protect the public from future crime, and are not disproportionate to the conduct or danger posed by Mr. Anderson, and that Mr. Anderson's criminal history demonstrates that consecutive sentences are necessary to protect the public. For all the cases remaining, you have 413 days of jail credit that will go towards the sentence I've just imposed. You will also get credit for the future days you spend here before you are transported to the appropriate institution when you are finished serving your prison term. The State of Ohio Adult Parole Authority will have a mandatory 5-year period of supervision. It's called post-release control. If you fail to meet the terms and conditions of any post-release control supervision, the Adult Parole Authority could modify or extend your supervision and make it more restrictive. They could incarcerate you for up to half of the sentence I've imposed here today. They could charge you with a new offense called escape, another felony where you would face additional prison time. And if you commit a new crime while on post-release control, you could face the maximum penalties under the law for that new crime committed. By virtue of your plea in case 683563, you are classified as a Tier 1 sex offender. That means that you are required to register in the county where you live, work, and go to school once a year for 15 years. If you fail to register, fail to verify your residence at the specified times, or fail to provide a notice of a change in residence address or other required information, will result in criminal prosecution. There's a form I'm instructing your attorneys to go over with you, which will have all of the requirements laid out for you in writing. Is there anything further on behalf of your client, Ms. Julian?
Your Honor, would you also waive fines, fees, and costs?
Thank you. Yes, I am finding that Mr. Anderson is indigent, and I will waive fines, costs, fees, anything associated monetarily with these 3 cases. Thank you. And anything further on behalf of the state of Ohio?
No, Your Honor, thank you.
Thank you. We are adjourned. Hey, Lisa. Thanks, Jamie.
Thank you.
Dan DeRose with 19 News. You've been watching the sentencing of Preston Anderson. Very interesting sentencing in that the defense tried to say that the victim in this case is suffering from severe mental illness to the point that she left 50 plus voicemails in one day with the law firm representing Preston trying to say she loves him. He just spit. He just.
Are you okay?
Yes, I'm fine.
He just spit on the prosecutor. He walked over to her.
So that's not a charge?
Yeah.
Okay, I'm fine. Thank you. I'm fine.
Do you have that on video? Okay, thank you.
I'm sure you'll be hearing from our office.
I have the exhibits and the sheet.
thank you.
that I know we're gonna have.
Lisa, take a minute.
The good news is the prosecutor, you heard her say to the judge she is okay. You heard the judge ask if our photographer got that on video. Of course we did. You saw it. There may be further consequences. That could be an additional charge. I know that's seems hard to understand, but you spit on a prosecutor, a judge. That can be a form of assault.
Oh my God.
We see the bailiff checking with the prosecutor there. I thought it was very interesting they were allowing Preston to leave that direction. Normally, defendants, they walk around the other side of the table. You heard him saying, well,
something just happened to you. It's traumatic. I am traumatized just by being a witness in this. We can talk. You can have a minute to talk with Miss Julian any other day.
Okay.
This is not what you have to handle right now. Take a minute.
Thank you, Your Honor.
You're welcome.
you just heard the judge say she was traumatized, but what she just watched, she wants to make sure the prosecutor.
You're welcome. We will.
Would you like that on the record?
And it looks like that will be the confusion. We knew there could be fireworks today. We have seen outbursts from Preston Anderson in the past. In his initial appearance arraignment via video, he flipped off the judge, had some other colorful things to say, and you've just witnessed him on his way out to prison. Again, I think we saw something abnormal. Generally, the prisoner is taken around the other side, the closest way to get to that door. which is back to the holding cells. For whatever reason, he was allowed to come to the other side of the table, to be within reach of that prosecutor. I think him spitting on the prosecutor was probably the least of what could have happened. He could have lunged at her. He could have done any amount of damage that he wanted to. He had clear access to her. He was standing right there at the side of the prosecutor's table when he spit in her face. And so he will probably be facing additional charges. Again, that'll probably be up to the prosecutor's office. But you saw in this sentencing, there's clearly mental health issues on both parts. The victim in this case, and as well as Preston Anderson. He has a pattern of domestic violence. And what about that letter that he sent from the jail to her that was intercepted that said, these are the things you need to tell them so that I don't go to prison. You need to tell them about each and every injury and how you did it to themselves so that we can be together. The judge felt that that was enough of what appeared to be coaxing or coaching of his victim. The victim, as you heard from the defense, has apparently some mental health issues herself. There was a question of 3 videos that have somehow gone missing, according to the defense, that were on Preston Anderson's phone, where he recorded her supposedly injuring herself in multiple ways, cutting herself, pouring hot liquid on herself. But again, the judge is siding with the prosecution, saying there's a pattern here. That letter from Preston was extremely damaging. The phone call that was played where he was trying to explain she meaning the victim, needs to stay away from the court so that she can't be there and point out who did this to you. So a very difficult domestic violence situation here. Again, also dealing with mental health on both parts. Again, we expected fireworks from Preston. That's exactly what we got when he spit on the prosecutor on his way out to prison. We will have much more on this. Our reporter Winnie Dorch was in the courtroom. You saw her. She will be covering this throughout the day as we have updates in our 11 o'clock news, our noon news, and then, of course, 3.5 hours of news starting at 3 o'clock. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.